Good morning, my name is Fiona Scolding QC and I will be chairing this session today alongside, and we're very fortunate to have, two of the barristers who appeared in this case on opposite sides, and also Matthew Fraser, who appeared with Richard Drabble in a predecessor case concerning housing benefit and the benefits cap, the case of RR, which went to the Supreme Court in 2019. As you all know, the SC case is exceptionally important, not just in the area of social security law, but also more generally in terms of the court's approach to Article 14, the court's approach to the UN Convention on the Rights of the Child, and the court's approach to parliamentary materials more generally. So even for those of you who have only a passing acquaintance with the child tax credit and the universal credit regime, should hopefully find a lot of food for thought. Just a couple of housekeeping points. Firstly, your microphones are automatically muted, so you won't need to adjust your local settings. We really do welcome questions because we have all had a very lively debate about this case before we've come online this morning. Please submit them via the Q&A section, which you will find either at the top or at the bottom of your screen. If you would like to remain anonymous when asking a question, please tick the anonymous box before submitting it. We will endeavour to answer as many of your questions as possible at the end of the presentations. This webinar is being recorded. You will receive a link a couple of days afterwards, and it will also be available on our YouTube channel. I think grand number of viewings, 5, which includes all of our relatives, I would imagine. If your connection's lost at any point, please just rejoin using the original link. So as I mentioned, we are very lucky in the speakers that we have today. I will be leading off, speaking a little bit about the issue of SC and the impact on women, so the indirect discrimination under Article 8, that claim and its interrelationship with Article 14, and a little bit about the facts. Some of you may well be very familiar with the facts, but others may not. We then have Yaaser, who was the junior counsel for the Secretary of State for Work and Pensions, alongside one of our colleagues, Galina Ward, led by Sir James Eadie, who's going to tell us about best interests and the relevance of Article 3 and the use of parliamentary material. We then have Matthew Fraser, who again, as I mentioned, was Richard's junior in a predecessor case, RR and the SSWP, about disapplying secondary legislation when it breaches human rights. He's going to be talking to us about manifestly without reasonable foundation and the amount of deference, the margin of appreciation. It's called different names in different cases, in cases involving social and economic policy choices. And last but by no means least, Richard Drabble, who was the lead counsel in both the SC case and in a number of predecessor cases, talking about the potential change in mood from the Supreme Court about these sorts of claims. So turning first to the impact on women, I'm just going to set out the facts very briefly so that you can understand the context in which we will all be discussing things. Under the Welfare Reform and Work Act 2018, there was the introduction of what's known as a 2-child limit. In effect, what happened was there is now a limit on the sums of money that people could obtain under children's tax credit or universal credit. As we all know, all of these various benefits are merging into one and pretty much have merged into one by now. It came into effect on the 6th of April 2017. This is separate to child benefit, so there are various different forms of child tax credit. There are 3 different forms that you can get, and it's aimed not just at those who have no income, but also those who are on low income. So it's a tapering benefit. In other words, the more you earn, the less you obtain. And it's probably important to say at this point that it was only the children's tax credit which limited the sums of money that you could be paid per child. Housing benefit, child benefit, working tax credit, there is no limit on the number of children for whom one can receive benefit. And let's just talk about the two appellants in this case. We can get lost sometimes in the midst of talking about the law, about the people at the heart of this. SC had 3 children living with her, for whom she was the sole carer. Her youngest child was born in July 2017. Her CB had 5 children, the youngest of whom was born 2 weeks after the law came into force. Again, she was the sole carer for her children. So, why was this 2-child limit introduced? It was introduced following a proposal in the Conservative Party's manifesto in 2015 to reduce spending on welfare benefits. And it was felt that the tax credit expenditure had more than trebled between 2000 and 2010, the figures which were presented to the court, no more recent figures, or there's certainly no discussion within the speeches, the speech of Lord Reid about that. There was a Treasury impact assessment, as there always is, accompanying money bills in effect, which said that without such cuts, and this was one of several cuts which were put in place, there would need to be even steeper reductions in other areas of public service spending. And the estimate was that this would save 1.365 billion by 2020 to 21. And what was absolutely clear when it was introduced into Parliament was that women would be more likely to be affected. 90% of lone parents are women, and more lone parents are in receipt of child tax credit. It is a truth universally acknowledged that women who bring their children up on their own tend, on the whole, to live in significantly greater levels of financial hardship and poverty than those who live or bring their children up with others. And the rationale, other than saving money, was also that those who receive benefits should make the same financial decisions as those in work. And I just pause now simply to say that a number of people who receive child tax credits are in fact in work. So I just pose that question there, but are in low paid work. It's also important to recognise that the issue of limiting benefits to only 2 children was the subject of vigorous discussion in Parliament. There were endless briefing papers that were produced, including one by the Child Poverty Action Group of 283 pages to various committees and to various MPs, the Child Poverty Action Group being the estimable organisation which brought the SC claim on behalf of the 2 women. The matter was also scrutinised by the Joint Committee on Human Rights and the House of Commons Bill Committee. The Equality Human Rights Commission submitted various changes saying that they had significant concerns about the impact of this bill. And there was extensive debate both in the House of Commons and in the House of Lords. And Lord Reid made a point of identifying that the UN, Lord Reid, who's given the sole speech in this case, identified throughout that the UN Convention on the Rights of the Child and the European Convention on Human Rights were extensively discussed and debated when the debates took place, both in Parliament, both in the Commons and in the Lords. So there were various legal arguments deployed. The first one of which was the limit compatible with Article 8 of the European Convention. Then was it compatible with Article 12, which is the right to marry and found a family? And even if it wasn't a breach of the substantive articles, was it discriminatory under Article 14 because obviously of the disproportionate impact on women, read with either Article 8, the right to privacy, or Article 1 of the first protocol? So those were the legal arguments. The argument as put by Richard and his colleagues was not that there was a direct impact on Article 8 on women's psychological integrity and dignity, which was the way that it was put, but that there was an indirect imposition because the limitation was designed to impact upon the reproductive choices of women, because they had to decide whether they were going to have a family or to have a child for whom they submitted inadequate financial support was available. And that if somebody was pregnant, and certainly if they were pregnant at the time that the law came into force, they may have had to consider abortion, something which they would not otherwise have required. And they cite Prayed in Aid the infamous case of Botta and Italy, which talks about psychological integrity and dignity, in that case in the context of those with disabilities, but it applies more generally. So what the court decided was that the evidence of both SC and the other appellant was that both of them in their witness evidence said, even if I had known about the 2-child limit, I still would have kept a child because of the views that I hold about abortion, or because that's just the way it was. It wouldn't have made any difference to my behaviour. Both the High Court judge, Mr. Justice Ousley, the Court of Appeal, which included Lord Leggett, who obviously is now in the Supreme Court, rejected the view that discouraging larger families was not an aim of the legislation. And what they said is there wasn't any evidence that legislative change had any impact on family size, and in particular, the US, which has various forms of legislation like this, both at a federal and a state level, found little or no effect on the impact of the numbers of children born to a family. And in particular, Lord Leggett in the Court of Appeal said the aim of the legislation was to encourage people to think about whether or not they could afford to support additional children, but did not discourage them from having children at all, i.e. the link was too remote to say it would have had a substantial impact on the decision whether or not to have a child, and therefore on one's psychological integrity. Now, and I'm just going to leave you to read what Lord Reid says at paragraph 32 of the speech, and make your own mind up as to whether you agree or not. The issue around Article 12, which is the right to found a family, and obviously as the European Convention on Human Rights was written just after the Second World War, when the idea of cohabitation was limited and the idea of being a single parent was also extremely limited and didn't happen very often, or rather it did happen very often, but it was subject to societal pressure and shame, that the rights under Article 12 is the right to found a family within marriage, and that neither claimant was married or in fact wished to be so. And the court very swiftly said, well, in that case, Article 12 isn't engaged at all in this case, because there isn't any obligation upon a state to provide the material means for people to found a family, even in marriage. So, Article 14, however, the first question which the court had to decide was, and as you know, Article 14 is the non-discrimination element. So even if something isn't a breach of the substantive articles, if it comes within the ambit of one of the main articles under the ECHR, and obviously it has a discriminatory impact, then Article 14 can be engaged. And Lord Reid, and I think none of the previous courts had found any difficulties in finding that welfare benefits which are designed to facilitate or contribute to family life were likely to fall in the ambit of Article 8. And the judge cites a number of cases, all of which say that. What the judge then had to go on to decide was whether or not there was differential treatment of women in the context of the legislation as I've explained it. And he said, well, there's no differential treatment on the grounds of sex obvious on the face of legislation. It doesn't say, well, women get X, whereas men don't get it. And therefore, there was a discussion about how far indirect discrimination. Now, those of you who are familiar with the Equality Act 2010 and its predecessors will know all about that. It's an ostensibly neutral practice, but which in effect has a disproportionate impact on gender, disability, race. And the court sets out a reasonably lengthy explanation of the various case law and formulates the rule. And this, I think, will be helpful for all of you in future cases where there is a neutral measure that affects a disproportionate number of members. And I'll let you read the rest of it. So the state, so in effect, can you demonstrate that there is a disproportionate treatment? Then, or unfair, then that burden shifts to the government or to the state or to whoever it is who's the respondent to show that the measure is proportionate, hence the discussion of manifestly without reasonable foundation that we'll come on to. So, was there indirect discrimination here? And this is where the court said, because the discrimination is on the grounds of sex, and as you may or may not know, there are some discriminatory grounds which are set out in the article, Article 14, so that's sex, race, disability, ethnicity, national origin, all of which are considered to be really the sort of the cardinal anti-discrimination grounds. And if you fall into one of those grounds, then very weighty reasons have to be put forward. And that's something which the Supreme Court has said on a number of occasions, and which the European Court of Human Rights has said on a number of occasions. However, and I think this is interesting, what Lord Reid did say in that case is he didn't necessarily agree that in cases of indirect discrimination on the grounds of sex, the same weighty reasons necessarily applied, and referred to the situation of the Supreme Court in the United States, which says, in effect, for direct discrimination, it's very weighty reasons. For indirect discrimination, the reasons can be, shall we put it that way, a bit less weighty. He went through the various things and identified, in effect, it was it that the essence of the question, was it proportionate, given that most single parents are women, a third of people who claim child tax credit were single women, and at least 50% of the parents who were married or in relationships or bringing up children jointly were women, so that women would be disproportionately affected. So was there indirect discrimination? More women were affected than men, as more women were obviously bringing up children. But Lord Reid described this as an objective fact. No suggestion that this is a result of discrimination on the grounds of sex. Well, I'm not sure Lord Reid really, well, I think that's unfair. I'm going to come on to have a very brief conversation about what I may think about that. The differential impact on women is not a special feature of this measure, but in effect is inherent in any measure which is impacting on child-related benefits. And that must be the case, because all child-related benefits indirectly and disproportionately impact women. And in effect, the evidence that the government also led was that any spending on benefits or any limits of benefits would always have a disproportionate impact on women, because women are more in receipt of benefits and more women are poorer than men. And what the court said is, well, we don't think it was indirect discrimination, because we think even if it was proportionate, because there was no alternative suggestion made which would have had a lesser impact, and that the importance of the objectives justified its enactment, in effect, because Parliament had gone through that process. And I'll leave Matthew and Richard and Yaaser to talk about that. My thoughts were, firstly, I think this case shows the limits of the law to address structural inequalities. I mean, I think it is, I think it's very interesting, the fact that the court says, well, it's not obvious that it's discriminatory on the grounds of sex, when we all know that women are poorer, and that is because of the way that society has treated women, and because more women than men bring up their children that they have. That therefore means that they tend on the whole to suffer significant financial hardship. And we also know that women have been disproportionately impacted by the benefits cuts which have happened generally. So I kind of answer the question as to the fact I think it demonstrates how limited the law is to address real issues of structural inequalities that exist within our society. What I was also thought was interesting was the absence of forensic analysis, certainly in the Supreme Court, as to how far the stated aim in respect of parents in work or not was justifiable, given that child tax credit is given to lots of people who are in low paid work. And because it's a tapering benefit, it was invented particularly for that reason, to supplement low paid work, as well as to give money to those who are not in work. It also demonstrates various other factors to do with the court's desire not to interfere in spending allocation. But I would ask again how far the court should, could, ought to have examined the financial position of women and looked at the structural inequalities when reaching their conclusions. So that is the end of my talk. I now pass over to Yaaser.
Hello, Fiona. Thank you very much for that. Hopefully you can hear me and see me. So I'll proceed unless I hear otherwise. Good morning, everyone. Great to be back after a summer break. Hopefully you've all had at least some rest. And what better way to do that than to try and digest what is an important Supreme Court judgment, not just on the facts of this case, but also more going into the future on the issues here, but also on trying to understand where the Supreme Court is going. So, and as Fiona said, I should admit first, I said I was instructed in the case on this occasion for the defendants. I'm going to be discussing two particular aspects of the judgment, both of which were dealt with at some length by Lord Reid as preliminary matters. The first relates to the use of international law and international material, and the second relates to the use of parliamentary material. Both, as I say, important issues for many cases going forward. So this is my list of overall topics I'll be going through, looking at how Lord Reid dealt with them in principle before seeing how they impacted in this particular case. And before I do that, I just want to spend a moment talking about what is perhaps a background factor that led to this particular decision at this particular moment. And I understand Richard will talk later more generally about perhaps the change in mood that one has seen in the Supreme Court. I'm going to touch on one very specific element just for a moment, and that is the composition of the Supreme Court, something that is quite close to my heart because I worked there as a judicial assistant for a year in 2014, and I was there when SG, which was the first benefit cap decision, was being decided. And so being there, you get to know the personalities very well, not just on a personal level, also very much on a professional level. And as you will be aware, it's undergone quite a shift in personnel over the last couple of years. And so to illustrate that point, in a moment, I'm going to be engaging all of you in some audience participation. So what you have here is on the left, you may remember the DA case. That was a challenge to the revised benefit cap decided in May 2019. I remember that very well because I read it when I was in Venice whilst on a holiday at a wedding, which gives you an insight into how fun I am. But then you also have SC on the right-hand side, which is obviously why we're here today, decided 2 years later in July 2021, just a couple of months ago. Both had 7 justices on the panel because it was deemed that the significance of the issues warranted the enlarged appeal. So my question to you as the audience, and hopefully you can participate, and I'll show you how to do that in a moment. My question to you is how many of the same justices were in both DA and SC? And I'll give you bonus points if you can name them. So hopefully that has now been launched and you can see it. If you can't see what you're supposed to be doing, oh, I see that some people are participating, so that's great. So just choose how many justices you think were in both. I can see numbers increasing. All right, so the numbers are just coming in. I think they're just slowing down. Very interesting. So 4 of you thought that there were either 0 or 7 justices exactly the same. For both. That's not correct, unfortunately. The correct answer, which a plurality of you got, 30% of you got it right, that there were 2 justices that were on both bench in DA and in SC. And 24% of you thought it was 3, and then 15 and 13% thought it was 1 or 4. And then, as I say, there was 4% of you thought it was 0, 4% of you thought it was 7. I can share the results there. I think hopefully you can now see those. But yeah, as I said, a plurality of you are correct. So if you now look back at this slide, you can see I've put it there in pictorial form. The bench in DA on the left and the bench in DA on the right, and you can see that Lord Reid and Lord Hodge are the only 2 judges who were there in both. Lord Hodge gone from being the most junior member on the panel to the deputy president in 2 short years. And so the panel you see on the left, they were all there when I was there. So there was a great degree of consistency for at least 5 or 6 years when all those characters were there. But 2 years later, you have a completely different composition. And I think it's fair to say probably that may go some way to explaining the different approaches in the analysis in SC, not just the number of judges deciding which way, not just the number of judges who had departed, but also the specific personalities departing and joining. I won't say anything more about that. All right, so moving on to the first of my issues that Lord Reid analysed as a preliminary issue, the relevance of international law. And so first of all, why was this even an issue? The reason why is because, as you may know, the Convention on the Rights of the Child, the UNCRC, and Article 3, Best Interests of the Child, have been relied upon for some time now in these Article 14 ECHR cases relating to decisions on benefits, resource allocation. And then the parties agreed statement of facts and issues, following on from the previous decisions such as DA, one of the agreed issues included, and I quote, whether the UK's obligations under the UNCRC have been breached in the present case. Not whether that was an appropriate type of question to ask, but whether there had in fact been a breach. So that is why this was an issue. And you see Lord Reid dealing with this point at paragraphs 73 to 96 of the judgment. And I've just set out there how he frames it at 73, whether it's appropriate to determine whether the UK has violated its obligations under unincorporated international law, considering difference of treatment is justified. Sets out the question there. And then to cut a long story short, this is what he finds at paragraph 91, essentially no, and it contradicts a fundamental principle of our constitutional law. So that's to cut a long story short. To cut a long story a bit longer, this is his analysis. He first repeats the fact that our legal system operates on a dualist basis, i.e. treaties between states create rights on the international plane, but they don't create domestic rights and obligations and cannot be enforced in domestic courts without incorporation. And he cites the International Tin Council case, which is a very well-known case standing for that proposition, gosh, 30 years ago now. So that was the general position under domestic law. And then he goes on to ask whether the Human Rights Act and the incorporation of the ECHR, whether that requires a different result. And again, he concludes no. He says the European Court clearly does use international law in some ways. And in the first 2 bullet points say why. They use it to have regard to international law, to avoid conflict with other treaties so far as it can. So there's kind of an interpretational tool. But also it uses it, and then the second bullet, as evidence of a European consensus, evolving principles, informing interpretation, and also things like width of margin and proportionality. So he says it is relevant to that extent, but the court does not have the European Court does not have jurisdiction to determine whether states have complied with unincorporated international treaties. So it doesn't ask that question, has there been a breach of Article 3 UNCRC? Now, at this stage, you could probably be forgiven for thinking, well, why is it that this is the first time this is expressly and emphatically being said by the Supreme Court? Because there have been loads of cases on these sorts of issues. That perhaps be fair way of thinking, you see there that there are 4 recent Supreme Court cases in which at least a majority of the justices considered whether there had been a breach of Article 3 UNCRC. And SC ultimately says, Lord Reid says, and everyone agrees with him, they were all wrong to do so. Not that necessarily changed the outcome, I think he says actually it didn't change any of the outcomes, or even necessarily the reasoning, but essentially they were all wrong to undertake that analysis. And he says that misunderstanding has appeared in some recent judgments of this court, emanating from ex nostria, which was a case about adoption by unmarried same-sex couples in circumstances where unmarried different-sex couples could adopt. And that was a case from 2013. So that's where the Supreme Court, some of the analysis started to go wrong, albeit that ex nostria didn't undertake that type of analysis. So there was a misunderstanding of that judgment. And so what he finds is that properly analysed, the best interests of children, i.e. this international obligation under Article 3 UNCRC, is a relevant consideration. It's relevant, but no more than that. What you don't do is apply UNCRC directly or determine where the national authorities have complied with their international obligations. So that's the overall position. That's the takeaway. If you go away from my talk, one thing today, that's what you go away with. But he does go through those cases, those 4 cases, and he points out where they went wrong, but the fact that they didn't make a difference in the end. So we have SG, which is the first benefit cap case. And you have Lord Carnwath, Lady Hale, and Lord Reid all finding, Lady Hale and Lord Kerr all finding a breach of Article 3 UNCRC. But in that case, Lord Reid, Hughes, and Carnwath said it didn't matter ultimately to the A1P1 analysis. Even in that case, Lord Reid assumed that there had been a breach of Article 3, but found it didn't make a difference. You have Mattison, which is a case about allowance being paid to parents of disabled children where their child was a long-term patient in hospital. And Lord Wilson, with whom Lord Reid agreed, found that Article 3 UNCRC had been breached, as there would have been a breach of Article 3, but that he would have found a breach of the ECHR anyway, regardless. So in SC, Lord Reid says, well, the breach of Article 3 wasn't part of the ratio of the decision and should be regarded as per incuriam, i.e. without proper consideration, because it wasn't referred to cases such as the International Tin Council. You then have Inri McLaughlin, a case about the eligibility of surviving parents to receive widowed parent allowance if unmarried to the parent who died. And there, the Supreme Court found that there was a breach of Article 8 with Article 14, and that was reinforced by an incompatibility with the UNCRC. Lord Reid wasn't in that case, but in SC, he says, well, that was very much obiter then. And then finally in DA, the revised benefit cap case just talked about, Lord Wilson found that there was no breach of the UNCRC in that case, or they considered it fully, and that the decision wasn't manifestly without reasonable foundation. And in this case, in SC, Lord Reid says, well, the remarks about UNCRC didn't form part of the essential grounds of the decision. So he goes through all of these Supreme Court cases in the last few years and says why they undertook a mistaken analysis. Quite significant, really. And then this is kind of where he distills what proper analysis should be. And you can see, that's paragraph 92, there could have been no objection if he, Lord Wilson, had instead treated the best interest of children as a relevant factor in the court's assessment, not a primary consideration. So what's the takeaway? Don't say that as a lawyer for your client, as a claimant, don't say the decision amounts to a breach of Article 3 and that means breach of ECHR, but do say Article 3 is relevant consideration and considering proportionality. So that's the change. All right, and then in a moment we'll see how this affected the decision in SC. I'm aware that I'm perhaps being slower than I thought I might be. But I want to deal with very quickly with a related issue, which is the use of UN committee materials, general comments, state reports, that kind of thing. This is sort of like the less interesting spin-off to the main point, which we've just dealt with, like watching Joey after Friends is finished, but important nonetheless, and actually requires moving off SC for a moment and looking at a judgment that was handed down on the same day, deliberately, no doubt, because they cover similar issues. And that is the decision of AB. I'm just going to go through this very quickly. That was an Article 3 case dealing with whether the solitary confinement of a child was a breach of Article 3. And in that case, the claimant relied on general comments and country reports to distill what the meaning of solitary isolation was, that kind of thing, solitary confinement was. And that was criticised by Lord Reid, again, judgment for the court. And he came up with these principles. The conclusion is at the top that the legal authority of material from UN committees who monitor these conventions, there it says the legal authority of those material is slight. It should never drive a conclusion that UN convention has been breached, which in any event you shouldn't be doing because of what's said in SC. And that's because they're not made up of lawyers, they're not judicial bodies, that's not their function, they have no power to make binding decisions. Things like general comments don't have a defined status and don't contain this type of legal analysis that you would expect from a court. And so, sorry, just going back to that. Anyway, so there we go. So those are the principles we derive from AB, same day on SC, but clearly in lots of cases, including SC, claimants rely on, or anyone relies on those reports of committees. That's now been criticised. So, all right, back to SC. How did the analysis we've seen just translate into the facts of the case? Well, at the top, you see the group and the comparator being considered here is just the Supreme Court focused on the children groups, discrimination between those living in more than 2 children households and those in fewer. And you see Lord Reid's analysis relating to the children of interest of children specifically there, accepting that the best interests of children remain relevant, but that interest of children could cut both ways there, you see in that last paragraph. But then in the same paragraph later on, here is the significance of the new analysis, because it shows it's just one factor and not necessarily a primary factor, i.e. best interest of children, because now much weight is put by the court onto how Parliament has cut the cake for other members of society as well. And so overall, Lord Reid took the view that it wasn't for the court to upset the balance or the judgment made by Parliament. That was not in the end a legal issue that could be determined using legal methods of analysis. So that's the change there, focus on whether Parliament decided to prioritise other members of society. Moving then finally onto the use of parliamentary materials. And the relevant part of Lord Reid's judgment are paragraphs 163 to 185 there. And the issue is relevant here in this case, because on the one hand, the appellants were arguing that there was no evidence to show that Parliament had acted in accordance with the procedural requirements of Article 3 UNCRC. What are the procedural requirements? Well, you find them in UNCRC general comment. And that general comment says, well, you have to look at the evaluation of the possible impact, whether the right has explicitly been taken into account, how it's been respected, etc. Now, obviously, CAB now for the authority to be derived from general comments such as that. But in any event, that was what the appellants were doing in this case. And the respondents argued that, well, we've seen various materials being put forward by government before Parliament, and that therefore this shows relevant considerations have been taken into account. So that's why this issue was relevant to the Supreme Court. And Lord Reid comes up with these important principles, some of which have already been said in the past, and which are pretty standard. I'll leave you to read those now. But I want to emphasize importantly 3 and 4, the will of Parliament is expressed solely in the legislation which it enacts, and parliamentary decisions are not necessarily capable of being rationalized and kind of reasoned in the same way as in courts, because the legitimacy of their decisions are accepted because of the democratic credentials of MPs, not because of the quality of the reasoning involved. And then over the page, you see again number 5, so the intention of Parliament is essentially a legal construct rather than discovered by empirical investigation. So in other words, parties shouldn't be going through what was before Parliament to work out, well, how is Parliament reasoning? That's not what Parliament is. Parliament is made up of a body of democratically elected individuals, and the end product is in the legislation. And so where does that leave us? Well, where the Parliament considered the matters relevant to compatibility with the ETHR is a relevant factor, But the court, and this is said expressly by Lord Reid, the court should only conduct a high-level review of whether the topic was raised before Parliament, not digging into the detail, not digging into exactly what was put before whom and when. And importantly, the courts must not treat the absence or the poverty of debate in Parliament as a reason for supporting incompatibility. The absence of that debate may be a reason going towards proportionality, but the absence of that debate can't count against legislation. And so how was that applied in SC? Well, it was applied quite shortly. Lots of the facts have already been recited by Fiona in her talk, but this is one of the concluding paragraphs which kind of shows you what the new approach is. And you can see Lord Reid saying it was approved by Parliament subject to amendments after a vigorous debate of which the issues raised in these proceedings were fully canvassed and in which the body supporting the appellant was an active participant. And that was kind of the start and the end of the analysis by Lord Reid in that case. So hopefully that shows you that on these two issues, preliminary matters that I've been going through, there is a big difference in how the Supreme Court was reasoning in the past and how it will be reasoning now. People will debate about how there has come to be that shift. I'll leave that up to you to decide or think about. But for me, that is the end of my talk, and I'll hand over to Matthew.
Thanks very much indeed, Yaaser. Good morning, everyone. I'm going to be talking about the use of the phrase manifestly without reasonable foundation, and the way in which that phrase is exercised in socio-economic cases such as welfare benefits in the context of SC. I'll start by saying that I'm not going to say manifestly without reasonable foundation 100 times. I'm just going to say MWRF, because otherwise my talk will be twice as long. So I thought I'd do a bit of digging and find out, if I could, when this phrase was first used by the European Court. I mean, this is my guess. I don't actually know whether this is right, but the earliest usage I could find was in the case of James against the United Kingdom back in 1986. So this is a judgment that was handed down before I was born, although I suspect Richard was probably in it. And this was a case all about, this was the complaint that was made by the Duke of Westminster, who was one of the biggest, still is one of the biggest landowners in the country, concerning the Leasehold Reform Act in 1967, which gave tenants of long leases a right to acquire the freehold of the property. And the Duke of Westminster, as the freeholder in many of these cases, thought this was unfair and said it was a breach of Article 1 of the First Protocol. And the court, for I think the first time, said, finding it natural that the margin of appreciation available to the legislature in implementing social and economic policy should be a wide one, will respect the legislature's judgment as to what is in the public interest, unless that judgment be manifestly without reasonable foundation. So there we see that usage back in 1986, 35 years ago. And here again is another old reference to this phrase, although slightly different, devoid of reasonable foundation. This is a case all about retroactive tax measures. So it has a very long pedigree when certainly in terms of public law cases, this concept of manifestly without reasonable foundation. Lord Reid considers, and I've obviously no reason to disagree with him, that STEC is the first time that the phrase has been deployed in the context of Article 14 and discrimination. And in STEC, what the court did was to identify the need to balance. This is paragraph 52 of the judgment. The need to balance, on the one hand, the need for very weighty reasons to justify differences in treatment on the basis of sex. So that's the test that Fiona was discussing earlier. But then setting that against respecting the legislature's policy choice as to general measures of economic or social strategy, unless MWRF. So that then is analysed by Lord Reid in SC, and he identifies that the principle, the MWRF principle, is often counterbalanced by a principle that's pulling in the complete opposite direction, namely a requirement to provide very weighty reasons to justify different treatment on so-called suspect grounds. What do we mean by suspect grounds? Well, there were various grounds that are included in this category, but one of them is sex, another one is nationality. And that Lord Reid then identified that there are cases from the European Court where, in relation to non-suspect grounds, where there is no balancing of the principle, the MWRF principle, with the need for very weighty reasons. And that's, for example, residence and prisoner status. So he starts to kind of look at these, and I mean, it really is an extraordinary and comprehensive analysis of all of the relevant cases dealing with this principle. As Fiona said to me before we started, there will be never any need to ever refer to any other earlier judgment when you're dealing with this, because it's all analysed in SC. Lord Reid then went he looked at a couple of cases, Vron 2 and Fabian, where although they are socio-economic cases, there's been a departure to some extent from a strict application of MWRF. So Vron 2 was all about displacement of people by the Turkish invasion of Cyprus, difference in treatment on the grounds of sex, in the provision of welfare benefits. This was a suspect ground case, and there was no reference by the European Court to MWRF. And then in Fabian, there was, again, so this is not a suspect ground, because it's looking at the difference in treatment between civil servants and private sector employees under a state pension scheme. There, the court referred to the MRWF principle, but then supplemented it by saying, well, you still can't discriminate, and you've got to be proportionate, and the court will have the final decision regardless of where you set the parameters of the margin of appreciation. And that's what fed into well, so before we go to JD, which is the big authority that Lord Reid was considering from the European Court, Lord Reid summarised what he saw as the effect of the European case law in the following terms of paragraph 130. So basically, if you've got a suspect ground case in a welfare benefit or pension context or some other socio-economic context, and the determinative factor has generally been whether very weighty reasons have to be shown, but that the court has taken into account the wide margin that's generally applicable in that field when making that assessment, whether a measure has formed part of a scheme intended to address historical inequalities, and the presence or absence of common standards among the contracting states have also been important factors. So that's how he summarises it. Then turning to JD and A against the UK, this was about 2 discrimination complaints, one of which was on the basis of disability, the other one was in relation to gender, both of them suspect grounds, and the court said that if you're looking at Article 1 First Protocol alone, so separate from any discrimination issue, then MWRF applies. But then when you're looking at A1, P1 in conjunction with Article 14, then there's a wide margin in principle, but you mustn't discriminate, and you must be proportionate. And the court expressed its view that MWRF is limited to differences in treatment that result from a transitional measure that's designed to correct a historic inequality, and that outside of that context, if you're not in that kind of very, very specific context, then the margin is, quote, considerably reduced in disability and gender cases, and very weighty reasons are required. So what did Lord Reid make of JD? Well, he was a little bit confused by those paragraphs that we've just looked at. Lord Reid criticises the Grand Chamber's reasoning in JD in those paragraphs is not actually accurately reflecting what the European Court's case law actually says. So it's quite interesting to see Lord Reid reaching that conclusion based on his very comprehensive assessment of the European Court case law, and he ultimately disputes the analysis that is articulated by the judges in JD. the Lord Reid then goes on to articulate what he sees as the appellant's primary argument about JD and how it establishes a new rule. The argument that was being advanced by the appellants was that complaints of discrimination where they are within suspect grounds are outside the scope of the wide margin, and the manifestly without reasonable foundation approach does not apply. And so instead, where cases are concerned with suspect grounds, they're governed by principles that are set down in other cases. Lord Reid's conclusion as to the European Court case law is paragraph 142. The 4 key points to draw from that, I think, are firstly, that there's a nuanced approach that's required, involved in taking a number of different general principles that are going to be pulling in different directions. The MWRF approach has neither been completely dropped, hasn't been completely abandoned by the court, nor is it to be applied mechanically. There's a wide margin for welfare benefits and pensions, and this is an important element that in the assessment, but that the application of it can be greatly affected by other principles and the facts. And the presence of a suspect ground is particularly significant as one of those factors, and there's a general need for strict scrutiny focused on the requirement for very weighty reasons, unless the issue is the timing of reform to address historical inequalities, that exception we were talking about earlier. And well, what I'll do in that case is just briefly take you through what I wanted to say, but without the benefit of slides, and we'll make sure that obviously all the actual slides are included in the packs that you get sent afterwards. So just as well, I have a copy of the slides with me, which is why I always make sure to print them out. After the Supreme Court looked at the European case law, what they did is they then started looking at some of the domestic case law that had arisen, considering some of those European cases, and in particular the case of Humphreys and the cases that have developed since then. And what essentially was being done by the Supreme Court in the domestic context, starting with Humphreys and then following on into cases such as DA that Yaaser was mentioning earlier, is that the manifestly without reasonable foundation test was being applied as a test, as an actual test in the welfare benefit context. And you had cases like in DA, I think it was Lord Wilson said that the sole question in a welfare benefits context is whether the MWRF test is met. And he even went as far as to say, let there be no future doubt about it. So, I mean, he really was trying to say MWRF is the only game in town, effectively. And what Lord Reid said about that and the line of case law that had developed since Humphreys is that effectively the Supreme Court had taken a wrong turn. So interesting listening to Yaaser talk about this in the context of the use of parliamentary materials, use of international material, the court kind of criticising its previous approach and saying actually we were wrong to do that and this is the way we should be doing it from now on. But basically Lord Reid said applying MWRF as a test doesn't actually reflect the case law from the European Court, which recognises that other factors may call for stricter standards, for example the application of in suspect grounds contexts. And at paragraph 51, Lord Reid said that the question is more complex than a test of whether the policy choice is manifestly without reasonable foundation might appear to be if that were regarded as the entirety of the inquiry. MWRF, he went on to say, does not replace or supersede the requirement for very weighty reasons where suspect grounds are an issue. So in terms of the key conclusions to draw from SC on MWRF, it still has a part to play. It still has a part to play, even in suspect cases outside of the context of traditional transitional measures. The Supreme Court was very clear that a new approach needs to be taken, departing from the approach that had been taken since Humphreys. No more applying MWRF as a test. Lord Reid said a low intensity of review is generally appropriate, other things being equal, in cases concerned with judgments of social and economic policy in the field of welfare benefits and pensions, so that the judgment of the executive or legislature will generally be respected unless it is manifestly without reasonable foundation. So that's the kind of starting point. But as Lord Reid went on to say, the intensity of the court's scrutiny can be influenced by a wide range of factors depending on the circumstances of the particular case. And some of those factors are going to increase the intensity of the review, such as the need for very weighty reasons in suspect ground cases or best interests of children, even in a non-suspect case. And other factors are going to lower the intensity of review, such as the context being about a transitional measure. So what should the court do? It should avoid a mechanical approach, but in general terms, the court should be very slow to intervene in areas of social and economic policy, such as housing and social security. But as a general rule, differential treatment on grounds such as sex or race nevertheless requires cogent justification. And I think that the final thing that the Supreme Court said on this is that the MWRF principle is really just another way of semantically describing a wide margin of appreciation, and that really the court's primary focus should be on the question of whether a wide margin is appropriate in the light of the circumstances. So don't get hung up on whether it's an MWRF case or not. I think where does this all leave us? Well, in terms of some general thoughts on SC, I think it's interesting to note that when Lord Reid comes to apply all of this legal analysis to the facts in SC and draw conclusions, not once is the MWRF phrase deployed by the judge. So that's the first point. The second point is that it is all now, I think, quite messy, because you have principles going in different directions, and sometimes it just feels like judgments are sort of saying one thing and then saying the opposite. Okay, well, this is a case where we give a wide margin of appreciation, but actually then this factor means we have to give a narrow margin of appreciation. So what are we supposed to do? Firstly, what are decision makers supposed to do? And secondly, when people are seeking to bring a challenge against decisions by public bodies or secondary legislation, or primary legislation, how are they supposed to know whether their claim is going to succeed when it's so difficult, when there's so much of an exercise of judgment? But I guess the response to that is, well, how could it be any other way? I mean, the context that we're dealing with here is very, very fact sensitive. There are principles pulling in different directions. That's often the case in public law. So it really is just, I see Lord Reid as doing his best, basically, of trying to reconcile a number of different considerations. And I think after all is said and done, it's very easy to get bogged down in the semantic exercise of how do we specifically want to characterize the test that's applicable here, when in reality, in any given case, what's really going to matter is the facts and the judge's very fact-specific assessment of the merits of the claim. So I think that's my headline conclusion. And then I think one interesting observation from Lord Reid, I was just about to turn to the slide, I realised I didn't have it, is an observation that he makes at paragraph 52 of the judgment in SC, which I would recommend that everyone reads, because it's a kind of sort of a final observation from Lord Reid about MWRF, where he says basically challenges to the legislation to legislation in the UK on the grounds of discrimination have become increasingly common in the UK. They're usually brought by campaigning organisations who lobbied unsuccessfully against the measure when it was being considered in Parliament. They then represent the solicitors for persons affected and bring legal challenges. The favoured approach is to bring a claim under Article 14 because, in his words, it is so easy to establish differential treatment of some category or persons, especially if the concept of indirect discrimination is given a wide scope. And then he says, since the principle of proportionality confers on the courts a very broad discretionary power, such cases present a risk of undue interference by the courts in the sphere of political choices. That risk can only be avoided if the courts apply the principle in a manner which respects the boundaries between legality and the political process. And I think that's a very convenient point to hand over to Richard Drabble, who will be picking up that theme in more detail as to whether this signifies a change of mood by the Supreme Court. I'll pass over to Richard. Thank you very much.
I will pick up where Matt left off. And if I can come on to my first slide, saying something about the importance of SC. It is a very, very important judgment in my view. I said in the slide it's an important judgment, but it's probably rather more than that. It's repays reading for a variety of reasons of some fundamental constitutional importance. I think it does evidence a change of mood in the Supreme Court, with implications for a number of matters that should be borne in mind when thinking about human rights and social policy cases of this sort. Comes from my perspective, having been involved in 2 benefit cap cases and the human rights case of RR and a variety of other cases, and indeed Humphreys, comes at the end of a process in which you can see some members of the court, and in particular Lord Reid, becoming increasingly anxious about what they see as adverse implications of the form of analysis which very, very nearly succeeded in the first benefits cap case, which has bitten the dust in relation to SC. So if we take a step back, we have heard from Yaaser and from Matt and from Fiona that the case marks a change of approach in a variety of ways. It certainly does evidence a change of approach to manifestly without reasonable foundation. It certainly does evidence a change of approach to that established in Matheson and the cases of around that time to best interests of children. And I think equally importantly, it evidences a change of approach, or a much more sophisticated and developed approach to the nature of the relationship between the courts and Parliament. It's very careful, or Reid's judgment is very careful, to set out precisely what one can expect and not expect from parliamentary material. How adequate an answer that gives you when you're dealing with Article 14 or other convention cases, I don't know, but we'll see. Now, a couple of other preliminary points about this, about SC. SC, it's important to bear in mind, the obvious, was a challenge to primary legislation. The remedy sought was a declaration of incompatibility. So it was different from, say, the first benefits cap case, where the challenge was to secondary legislation, and where the attempt was to argue that the regulations, which were made by the Secretary of State and not by Parliament, that's an important factor, were effectively unlawful because of a breach of the convention. That route was not available in SC, which made it more difficult to argue, but it also means that when one comes to consider the implications of SC, we do not know how the thoughts of Lord Reid will pan out when it comes to considering the relationship between secondary legislation, possibly the result of affirmative resolution material, of an affirmative resolution. When it comes to considering the results of that affirmative resolution, secondary legislation, how far the principles that Lord Reid sets out in SC will carry across. That, I think, is a battle still to be had, but it is a battle that we probably will have. So going back, I say, and the point of these fairly short comments is to make some short comments about the potential implications of SC. Not in a matter of the formal law it decides, but in the atmosphere surrounding a number of issues. And the bottom quote says the issues include the attitude of the court to government policy, to political debate, to the role of expert NGOs and pressure groups, and interventions. Now that's all correct. Taking them step by step and just indicating what I think one should take away from SC about the likely attitude of the present composition of the court. The approach to government policy is a fairly traditional one. I'll have a quote on a slide in a bit about the how the court is very slow to react to adopt or agree with challenges to economic policy. Rate capping cases in the 90s are kind of a classic example. But that traditional approach gets a pretty tough formulation that you can expect to see Treasury Council going back to the formulation that's set out in the judgments of SC, which place what may be a traditional approach, but in fairly trenchant terms. To political debate, this is the analysis which I'll come to in a moment in Lord Reid's judgment about the relationship with Parliament is much fuller and more sophisticated than one finds elsewhere. It has its precursor in the environmental statement case in HS2, which was keen to stress the particular result of the particular constitutional result of the fact that a decision had been entrusted to Parliament, in that case by the hybrid bill procedure. Well, it's easy to say that the fact that Parliament is involved will make the courts slow to intervene, but SC does mark a fairly careful and deliberate statement of why that is. So we all need to be aware of that. And then Matt touched on paragraph 52 of the judgment. That's highly relevant to the next of my points in the last sentence on this first slide, the role of expert NGOs and pressure groups. We will see that Lord Reid was obviously unhappy about the fact that the CPAG had first of all intervened in the parliamentary procedures in the sense of producing a massive briefing notes, and was also actively pursuing the litigation by acting for the individual clients. I can't for the life of me actually understand what the complaint about that was, but there's an obvious unhappiness about it, which will come back. And I have met 2 or 3 times in the last 6 months or so, a reaction of the court in saying, well, we must guard against the continuation of politics by other means, otherwise policy submissions that are addressed at effectively, as the court would see it, the merits of the socio-economic issue rather than hard legal analysis. Now, finally, interventions. There's nothing in SC about interventions as such. I have a feeling that the court is already showing itself much less willing than it used to be to grant permission to intervene orally. I think the role of interventions is going probably on the downside, and that may be a reservation about in the present composition of the court about being drawn into policy debates. So those are the 4 things. Now, if I go on in the slide, Yaaser and Matt and Fiona have said all this already. But the 2 paragraphs on this slide are taken from the last 2 paragraphs of Lord Reid's judgment. They are the ultimate conclusion. Fairly short, but it's worth reading it. So what Lord Reid says is the assessment of proportionality, therefore, ultimately resolves itself into the question as to whether Parliament made the right judgment. That was at the time and remains a question of intense political controversy. It cannot be answered by any process of legal reasoning. There are no legal standards by which a court can decide where the balance should be struck between the interests of children and their parents in receiving this support from the state on the one hand, and the interests of the community as a whole in placing responsibility for the care of children upon the parents on the other. The answer to such a question can only be determined in a parliamentary democracy through a political process which can take account of the values and views of all sections of society. Democratically elected institutions are in a far better position than the courts to reflect a collective sense of what is fair or affordable, or where the balance of fairness lies. That is what happened in this case. The democratic credentials of the measure could not be stronger. It was introduced in Parliament following a general election in order to implement a manifesto commitment. It was approved by Parliament, subject to amendments, after a vigorous debate in which the issues raised in the proceedings were fully canvassed. There is no basis consistent with the separation of powers under our Constitution on which the courts could properly overturn Parliament's judgment that the measure was an appropriate means of achieving its aims. So that's the end. Those are the two concluding paragraphs in Lord Reid's judgment. They are firmly based in earlier passages to do with the court's relationship with Parliament and his view of the nature of proportionality. So I think we can expect to see that sort of fairly developed approach being a major driving force for challenges of this sort in the future. Good. I've managed to swap over get on to the next. Now, the stepping stones on the way to that conclusion involve the following: consideration of deference and manifestly without reasonable foundation, consideration of the role of Parliament and the court's relationship with Parliament, and the Article 14 analysis, including the role of status. Just a word about MWRF. Matt is right that James, I think, was the first use of the phrase manifestly without reasonable foundation. It was, of course, a compulsory purchase case. The phrase was used by the Commission and the Strasbourg Court repeatedly afterwards in relation to taxation policy, and bounced over into STEC in a social benefits case. The one thought I would wish to say about where we are now with MRF is that and it's a positive thing, is that the approach that some lower courts, Court of Appeal, for example, have taken to MWRF, which to say effectively is Wednesbury, is dead and buried. I am not convinced that we are going to thank Lord Reid for his analysis. It's terribly thorough, but it is going to mean that we're going to spend time on each and every case trying to look at the individual factors and reinventing the wheel effectively. Consideration of the role of Parliament and courts, I'll say something very short about that in a moment, and as I will about Article 14 and the question of status. If I can move on to the next slide, there we go. I say that the issues are all interrelated. And this goes back to something Matt was saying. I've been feeling for some time that it's possible to discern in the court that a feeling that if a generous approach is taken to the requirement for status, any social policy issue is capable of being analysed in Article 14 and subjected to a discrimination analysis. And Lord Reid is obviously very nervous about the consequence of that. It's that drives, or at least needs to be read with, his approach to parliamentary, to the role of the courts together with Parliament. But on the actual facts of the case, the court did find that status was sufficiently in play, and finally found that the relevant group were children living in a household containing more than 2 children, as compared with children living in households containing 1 or 2 children. And then I don't think I need to spend any time on this slide, but it repeats much of what Matt has said about status. Just a marker for other issues. There is some doubt about whether an indirect discrimination analysis is available outside suspect grounds. And you'll see there a quote saying that every case in which the European Court has treated the concept as relevant, that indirect discrimination is the concept in that quote, as relevant as concerned a group sharing a common characteristic corresponding to a suspect ground, such as sex, sexual orientation, etc. Subsequently says that those grounds are discussed below. They don't include age, and he's putting down a marker which we may well have to revisit, that indirect discrimination doesn't have, there is an argument that indirect discrimination has no role outside those suspect grounds, and quotes Van Dijk and others as espousing that view. Say no more about that, we may well have to revisit that. So finally, let's go on to the last of the big themes before we move. First of all, necessary to address the relationship with government policy. I've set out in the slide a fairly lengthy quote which goes back to the Hammersmith and Fulham case, Bridge and Hammersmith and Fulham, and stressing the difficulty of applying Wednesbury in anything other than a very strict basis when you're dealing with the formulation of implementation of national economic policy. I said at the outset that's not a new thought, but this is a pretty kind of rather old-fashioned, if I can put it like that, formulation of the approach, which one hasn't seen in quite these crisp terms in the more recent past. But that's back where we are. And then if I can go on to the next slide, is to repeat, but I'm quite keen that we do actually see the language that Lord Reid used, but it's to repeat Yaaser's thoughts about the relationship with Parliament. And Lord Reid is very careful to say it's a constitutional fundamental to be borne in mind, is that the government is separate from Parliament, notwithstanding the many connections between the two institutions. A matter of daily reality, ministers and party whips have to negotiate and compromise in order to secure the passage of the legislation, which the government has promoted, often in extended form. In fact, as well as in theory, the legislative function belongs to Parliament and not to the executive. And you can read the rest of the quote. And if I go on to the next slide, this is obviously a major thought for Lord Reid. The quote says, next is the next paragraph to the one I've just read, in the judgment, the decisions which Parliament takes are not necessarily capable of being rationalised in any event. In the first place, Parliament does not operate only or even primarily as a debating chamber. It's also a forum for gathering evidence and for extracameral discussion, negotiation and compromise. Furthermore, the way in which members of Parliament vote will usually always reflect party policy and may be influenced by the discipline imposed by party whips. It follows that parliamentary methods of resolving disputes are very different from judicial methods. So he's saying you cannot look to parliamentary debates as a source of material to show that the analysis was careful or otherwise. The parliamentary debate is a fundamentally different exercise. As I say, I don't think we've seen that set out with that clarity elsewhere. And it's a thought which, like it or not, is undoubtedly going to be highly influential in the immediate future with this composition of the court. And then the last slide is actually from Lord Bingham. It's another thought which we're going to have to live with, which is that a dislike articulated by Lord Reid of the extension of politics by other means, of finding the court being absorbed in proportionality arguments which reflect what has already been said in debate. And there's the quotation, democratic process is liable to be subverted if on a question of moral and political judgment, opponents of the act achieve through the courts what they could not achieve in Parliament. And as I say, signs that is resonating. That's Lord Bingham in Countryside Alliance, so that's some time ago, but that's resonating now with the present composition of the court. And that's all I want to say. I hope we've just about delivered the timetable. Thank you very much.
And thank you, Richard, for, as usual, your excellent, erudite, and shall we say, as someone who knows practically more about this area of anyone else, it's a great privilege for us to have you speaking. And I like the fact that your dog was obviously not very happy about it.
It's not my dog, it's actually my daughter-in-law's dog.
Okay. Well, the dog was definitely demonstrating a degree of unhappiness with Lord Reid's analysis. If I could ask Matthew and Yaaser to come on screen as well. We have a couple of questions, one of which I think, Richard, you answered in your talk, which is in effect, would the analysis be the same if we were looking at secondary legislation rather than primary legislation, in particular, given that secondary legislation is often subject to the sort of negative resolution and therefore isn't subject to anywhere near the level of debate and scrutiny that primary legislation is in Parliament? Do you think that the analysis would be different?
Well, certainly on a formal level, the answer ought to be yes, because you are looking at the reasoning of an identifiable minister with secondary legislation, whether it's affirmative resolution or secondary resolution, and so that it's commonplace now for the submissions to the minister to be part and parcel of the evidence that's there in order to see what was taken into account and not taken into account. And that's because there's an identifiable decision maker in a way in which there just isn't if you're dealing with Parliament. It's Parliament being a multi-membered body, and for all the reasons that Lord Reid gives, very difficult to impute any particular line of reasoning to Parliament as a whole. But that doesn't apply to the minister. Whether anything's going to rub off more generally, I don't know. I think that's what I said when I was actually speaking earlier. So that's what I think. I don't know what others think.
Yes, sir. Matthew,
I think we've just had an insight into how Richard's going to argue it the next time it comes before the court.
It's particularly relevant in welfare benefits cases because so much of it and so much of the detail which could be discriminatory is set out in secondary legislation rather than primary legislation. The primary legislation very rarely does anything other than a very broad brush, particularly in these kinds of cases.
Yeah, I mean, what I would say is I've done loads of COVID cases over the last 18 months, and kind of all of that, lots of that has been secondary legislation. So you can see in that kind of context, these kind of arguments where, well, it's different to SC because that was primary legislation. You can see that kind of argument being made. But I mean, Lord Reid does focus on the fact that it's primary legislation. Again, he repeats it. So one can well see that Richard's position that it's very different, that would kind of take favour in the court.
I think, however, the issues around being very cautious before interfering with economic and social policy are still completely relevant, however, and the courts, irrespective of whether it's primary or secondary legislation, I think that this marks, if not a turning point, then I would say a retrenchment back to a more conservative with a small c position in respect of the intervention of the courts in these sorts of cases.
Yeah, I mean, I agree with that. And why has it happened? Well, I pointed to potential changes in composition. I heard someone else talk about the other day about the fact that it's all happened at the same time as these kind of suggestions, reviews into judicial review and Supreme Court and the Human Rights Act, and how it's possible that courts are kind of subconsciously picking up on that and showing that they are not kind of too activist, that kind of thing. So that's another possible reason why it's happening now.
That's very helpful. Now we've got two more questions. The first question is from someone who says, what's your opinion upon the current relationship between the court and parliaments following this case? Does the recently greater reluctance of the judiciary to challenge parliamentary decisions in respect of welfare, social and economic policy potentially leave Parliament without a valid check upon their ability to maintain structural inequalities? Perhaps the separation of powers now dangerously upholds and protects the sovereignty of Parliament at the expense of human rights. Should this change, or is the current balance appropriate in your opinion? So I think I will go first to Richard.
Well, I'm kind of going to park that because I think one of the thoughts that I had thinking about SC, just getting together the slides, is precisely how Strasbourg is going to relate to this, because it's one thing to say that you can't, the UK Supreme Court, can't judge the merits of a parliamentary decision in primary legislation, given the multi-membered nature of the body. But it's one thing that Strasbourg has to do all the time at the end of the day. I mean, at the end of the day, it will have to say whether or not the legislation that's under challenge, whatever the particular legislation is proportionate or not. So it's an exercise that can't be ducked altogether. And I can see the attraction of the last two paragraphs that I put on the slide out of Lord Reid's speech, but I do think they go a very long way, because it's impossible to read into that passage anything like a place for best interests or classic proportionality exercise. It's democratic debate is the be all end all. That can't be completely true. So time will tell, I think.
Yeah, and it particularly can't be completely true if you're talking about various parliaments doing various things which most of us would recognise are discriminatory. So, yeah. For example, if there were to be direct discrimination on the grounds of race or direct discrimination on the grounds of disability, and I think there may be a difference here between indirect discrimination and direct discrimination in terms of the approach that the courts may take. But I can't see something absolutely outrageous being subject to, you know, the courts completely saying we're not going to interfere because Parliament may have debated it, and it's all full of people who believe that sort of thing.
Yeah, but for what it's worth, I completely agree with that. I think there's room within Lord Reid's judgment for separating out a kind of discrimination, direct discrimination on a suspect ground, or indeed indirect discrimination of a particularly blatant sort on a suspect ground. I think there's plenty of scope for that sort of protection coming in. It's my benefits world, which is likely to be more heavily impacted by the approach.
Oh, apologies. Somebody just tried to telephone me, and I apologise for that. So, Matthew, do you have any thoughts you wish to add?
Well, I think the question whether the position leaves Parliament without a valid check upon their ability to maintain structural inequalities, which is the way that the question was asked, I think does depend on whether you think it is a valid check on Parliament to have a court effectively going through the merits again of something. I mean, I personally think there is something to be said for maintaining a distinction between whether something is correct as a matter of policy and the right thing for a Parliament to be deciding to do, balancing all the various considerations together, and then having a legal process that it ascertains whether there's a breach of somebody's human rights. And I think there is a valid distinction there, and that's been consistently recognised by the courts, and I think SC is a very strong restatement of that principle. And I think I agree with Richard completely when he says that there is still an enormous amount of scope, notwithstanding SC, to bring a number of very, very important challenges, to continue bringing very important challenges to in this context. And I think it's fair to say that Lord Reid, it's not like he can nor is he actually trying to close the door completely in relation to human rights challenges to whether it's primary or secondary legislation, whether it's in welfare benefits or anywhere else. And if what he's saying is, well, it needs to be very fact sensitive, and there are going to be all sorts of different factors that apply in any context, then the opportunity is still there in the right case to find a case where the factors are pulling against the strong wide margin of appreciation, and relying upon that to make the points that you're trying to make in relation to a breach of human rights. So I don't necessarily agree that what SC is doing is taking away a valid check on Parliament, I suppose, is how I would summarise my answer to the question.
Yeah, and I think if you look at the facts of some of the previous cases, I was just thinking about Matheson, which is a case, the facts of which I know quite well, and I was thinking even under Lord Reid's reformulated test, I think the parents in Matheson would have succeeded because the iniquity was so great, and the justificatory reason given by Parliament for leading to that differential was slight, shall we say.
Absolutely, and I think that goes back to something I said in my talk about how you can get really bogged down in the semantics about what the test is, but actually what are the facts of the case, what are the merits of the complaint here? That's really, and I mean, it's exhibited in the fact that Lord Reid, although he says that MWRF was applied incorrectly or approached incorrectly in Humphreys, he absolutely doesn't disagree with the actual analysis or the outcome in Humphreys. Which
leads us on to the next question which is being asked, which is, how does the case of SC square with the decision in Reid adoption, unmarried couple, which says that the courts are the ultimate safeguard against discrimination? Well, I think obviously that's true, because Parliament has enacted the Equality Act 2010, which enables the court to opine on discriminatory acts, even acts of Parliament, as does the Human Rights Act through the mechanism of Article 14. But I mean, personally, I don't think that SC changes that. What it does is just establishes a less interventionist approach, shall we say, or a less judicially active approach, shall we say, or a degree of caution, rather than saying you can't do that anymore. Yaaser, Matthew?
Yeah, I mean, so in Reid it's a Northern Irish case, wasn't it, about how an unmarried couple wanted to adopt a child, but because they were unmarried, the dad, who was not the biological father, couldn't be part of the adoption order. They said there's discrimination. I think in that case, Lord Hoffman said, well, there wasn't a Strasbourg case on that, and Lord Hoffman said in the appropriate case you can go further than Strasbourg. So I think the question is that approach of the House of Lords, well, sometimes you can go further than Strasbourg. How does that square with the SC approach, which is, you don't go further, you don't stay behind? I think that's a difficult question to answer. They're also fact specific. And relating to the previous question, I think often judges stand back and say, oh, that doesn't feel right, or I'm not sure we should be intervening, and then they work back from there. And that Reid case is kind of more of the type of, oh, that doesn't sound right. How do we get there? How do we get to the answer? And SC the opposite approach. So I think you square it by saying they're on very different individual facts, and kind of courts will come to the answer they want to by working backwards. But I agree with you that as a matter of generality, SC does show kind of more precautionary approach than previously, and certainly more in Reid.
And then the last question is whether or not SC would have been decided differently if it was brought before a differently composed court. And what does this say about justice, depending upon who the judges are, rather than what should be given the close application of the law to the facts? I'm going to leave Richard to lead with that.
So slightly unfair, because I argue both the cases, and there may yet be further steps to be taken in relation to it all. So I feel like ducking it, actually.
Okay.
The very first, it's worth bearing in mind, the very first benefit cap case was very finely balanced. We almost won, and I think I'm willing to say that I think the shift of emphasis, which has got an awful lot to do with the proper role of Article 3 UNCRC, I mean, has a lot going for it. It was the first time round was very unfortunate, because the government didn't really argue about the line that is now being taken in relation to UNCRC until submissions after the hearing. So it was argued very late on, I don't think one can take all that much out of the fact that you've got two different sets of judges, actually. But,
no. And I think obviously it is always thus, isn't it? The composition of the court always has a material difference, just because different people have different approaches to the law, because the law isn't isn't one thing, it's what one interprets it very often. I mean, so I was interested in the Article 3 issues, though, because obviously in both Wales and Scotland, there is the UNCRC has been enshrined in domestic legislation. And we are, I think it's proposed in Northern Ireland that will be the case as well. And therefore and I think there is a movement in England to enshrine the rights set out in the UNCRC independent legislation by children's rights groups, in which case those issues will become live again in terms of how you look at the general committee papers, whether or not that makes any difference. Because I would say, isn't looking at those general committee papers, I mean, I know they're not written by lawyers, I know they shouldn't be looked as a text, but aren't they a bit like looking at statutory guidance or looking at policy guidance issued by the relevant department? It's like, right, these are the people who've invented these ideas. This is the way that we think they might work out in public. So we should have a look at them, even if we don't say that they're the definitive statement of law. Or am I being far too generous to the Committee on the Rights of the Child there?
Can I just add one further thought in relation to that? I think even in England, it's not completely put to bed, because we do have Section 55.
Yes.
So it's a rather peculiar form of incorporation. But I mean, there's no doubt that you can directly refer to Article 3 as nearly incorporated in a Section 55 case. And I in the past have argued that it's completely unstable to have a world in which in Article 14 you can't directly rely on Article 3, but in Section 55 in closely related matters you can. Is that really going to stand the test of time? I'm not so sure about that. And that also obviously brings in state practice and general committee papers and so on, if you're arguing under Section 55.
Yeah. Yes, Matthew, do you have anything else? Just to say, Section 55 is the Immigration, Borders and Something Act. Which basically says that in those sorts of decisions, the best interests of children shall be a paramount consideration. I think that's right. Yes, and there's lots of cases, including Supreme Court cases, looking to see what that means.
Well, I mean, just a quick point on that. You have some pretty trenchant criticism of those reports by Lord Reid in AB, as I tried to show. No doubt people will rely on them, no doubt courts will consider them, but I mean, even you have cases of the European Court of Human Rights disagreeing with things that are being said in committee general comments. So I think they might be kind of be looked at, but I'm not sure how much weight is going to be given to them.
Okay, so they're sort of dead in the water.
I wouldn't say dead in the water, but they're
very
kind of
tool of analysis.
They're doggy paddling at the moment,
Don't tell my dogs.
Matthew, do you have anything you'd like to add?
Well, just on the speculative question of whether the decision would have been reached differently with a different composition. I mean, it's obviously a purely speculative answer, but it seems to me that you need to bear in mind that Lord Reid is the one who gave the lead judgment, and he has been on the court now for coming up a decade, I think. And so he's been there through a lot of these cases since Humphreys. I don't know if he was actually sat on the panel in Humphreys, but he certainly was. So he wasn't on the panel, but he was certainly around at about that time. And so I don't see it necessarily as being a question of different composition as much as he's clearly thought very carefully about all of this and has managed to persuade all the colleagues who are sitting on the bench with him that this is the right analysis. I mean, who knows what was going on behind the scenes as to who was driving it, but given that he's the one who's written the judgment, he's clearly thought very carefully about it and has come to the conclusion that he himself and a number of other judges took a wrong turn on certain things previously. So I don't necessarily see it as a question of composition as much as Lord Reid's changed his mind, which obviously lots of judges do and purely entitled to do.
Yeah, it's always hard when there's a sort of you veer off and then they veer back, but of course it's not uncommon in lots of other areas. So I think that's answered all the questions. I'd like to thank everyone for remaining patient, as I know we've run slightly over time, and I'd like to thank all the speakers for what has been an excellent set of talks. I'm excluding mine from that. I don't think I can really praise myself for an excellent set of talks, which have been extremely thought-provoking and which will hopefully assist all of you in your future practices. Thank you very much. Bye-bye.